Hello and welcome to another iteration of the IDEA Handbook webinar series. These webinars accompany the release of the new Handbook on Using Administrative Data for Research and Evidence-Based Policy, funded by the Alfred P. Sloan Foundation. The Handbook provides a series of technical guides and case studies on how to make administrative data more accessible for research and policy analysis. Today's presentation is on the chapter Model Data Use Agreements, a Practical Guide by Amy O'Hara. Amy is a research professor in the Massive Data Institute at the McCourt School of Public Policy at Georgetown University, and she's director of Georgetown's Federal Statistical Research Data Center. She also leads the Administrative Data Research Initiative at Georgetown with the mission of improving secure, responsible data access for research and evaluation. She was previously a senior executive at the US Census Bureau, where she negotiated DUA's data use agreements for federal, state, and local administrative data. So as you can see, Amy is really one of the foremost experts on administrative data access in general and data use agreements in particular. And this chapter gives a very constructive and practical introduction on the process of developing a DUA for an administrative data research project, including the role of different types of legal agreements in the data access process. Amy discusses considerations for both sides, researchers and data providers, and also provides an annotated template DUA.
Hi, I'm Amy O'Hara. I work at Georgetown University in the Massive Data Institute at the McCourt School of Public Policy. For the IDEA Handbook, I wrote the chapter on model data use agreements that is intended to be a practical guide. The scope of this talk is to provide an overview of data sharing, why you need an agreement, why you want an agreement, and what that can build on into the future. And so the objectives of data sharing should really be about having efficient, secure, and equitable access to files that are owned by one organization or agency that are sought by others. And it can't just be data sharing, which is data going from one party to the other. It might be data exchange where there's a bilateral transfer of data, or even data access where one party queries another party's data but never actually takes custody of an extract of it. And data sharing is really useful because it can be used to build knowledge in scholarly work. It can encourage additional data access by seeing success in one project that leads to another. And ultimately, it can build trust between the people that have the data and the people that want to use the data. So what are data use agreements? They're documents that describe what data are being shared for what purpose, for how long, and they can detail any access restrictions or security protocols that need to be met. They are equivalent to a memorandum of understanding. They're similar to a data use license, similar to a data exchange letter, and often are accompanied by or have embedded non-disclosure agreements. And the parties to a data use agreement is typically a data provider and a data requester. But sometimes there are data intermediaries that facilitate this, and that's especially useful whenever there are multiple sites involved in a project that needs to access data, or a single project that wants to access lots of different data streams. Having an intermediary that is taking care of some of these concerns with the data owner and the data user can be really beneficial. So I think of a project involving data as a giant balancing act. And it starts there at the bottom with data discovery. Are you even able to identify what data are out there that you might want to use? And can you get the owner to allow you to use it? The third step up there, data use agreements, the topic for this session. It's really critical to have a sound data sharing agreement. Otherwise, all of those additional layers are not well balanced. And so once you have a sound data sharing agreement, it is likely that it's going to specify your IT and security conditions, how data linkages can occur, how data can be warehoused and where it can be accessed from, the types of authorized users that can use the data, the computing environment, whether that's in the cloud or in a physical enclave. And then all the way up to the very top, whenever the results get produced, what sort of results can go out? And then how can people repeat this analysis or build upon this analysis? But all of this comes down to being able to identify what data are out there that can help your project, and also making sure that you can get access to them in a responsible way. So in a data sharing agreement, I think it's really important that there's a clear vision for how the data are going to be used and clear objectives for the specific projects that will be using the data. It's also really important for people to be using the same vocabulary. This is when a data owner understands the program that they run, that they have administrative data for, and they describe certain program participation aspects in a certain way. And then a researcher comes along and they might describe certain parts in the way that their discipline does. Making sure that you're talking the same language, that's really critical. There also ideally will be coordination across sectors. That's the public sector, the private sector, and organizations that would include universities and intermediaries that can facilitate the data access and get that specified in a data sharing agreement. This is going to require collaboration across a lot of roles and disciplines. And these are just some examples that I have here, that there will be practitioners and social scientists, different types of computer scientists and data scientists, but then also lawyers and regulators, and then the thoughts of the data subjects themselves. A lot of these groups are already working together, but we need to have better data transmission, so information transmission about who allows data sharing for what and where precedent already exists. So the goal is to get a complete signed data sharing agreement, and a data use agreement like the example that I have here that's between the Marshals Service and the Census Bureau. It took a while to negotiate. It includes a lot of very specific terms and conditions, and then once it's signed, that means that the data sharing is approved. That's the goal of getting the DUA. But then you have to wait for the transfer of the data and make sure that the data get used in the projects in accordance with what was in the data sharing agreements. So a framework that I like to think about when developing a DUA, it's called the 5 safes. And the 5 safes are safe projects, safe people, safe settings, safe data, and safe outputs. And the way that these can be embedded into a DUA is by making sure that you have very clear language on what the intended data uses are. And this is important whether it's the data owner, their side of writing the agreement, or the data requester, the user that's going to use the data in a project, for them to have very clear intended data uses and how they're going to handle the data, how they're going to get it. Is it going to be on encrypted disk? Is it going to be through an FTP? How they're going to handle the data, especially how they're going to handle the data that might include personal identifiers. And then what they're going to produce through their project after their analysis. What sorts of outputs are they going to make? And where do they expect to publish that information? Is this going to be something presented at different conferences? Is it going to be a manuscript? Is this something that's going to be shared with the press? Making sure that all parties understand the expected outputs is really critical. As I mentioned before, the acceptable data uses could also include how the data can be linked. And that would involve joining data either over time or across different sources. And that can cover different topics of analysis as well. So making sure that a DUA has all of these elements reflected in it and also includes those terms and conditions for what is the owner responsible for and what is the researcher responsible for, that makes for a sound DUA. It's also great whenever the DUA is accompanied by really good metadata. And so that's going to be data dictionaries or code books, information about the data being shared that often help the researchers use the data in a more appropriate way. But it's tricky because sometimes metadata doesn't exist. Especially with administrative data, if the agency that's generating it is only generating data about the services that they are providing their clients, they might not have put a lot of effort into building metadata because for their administrative purposes, they might not require any secondary use. So documenting the data for a researcher may not be a very high priority for them. So sometimes a researcher can articulate even in a DUA that they would request as much metadata as can be provided, but it might be something that they could even offer the data owner in return. Finally, a DUA should include what the reporting requirements would be. So while you have the data, perhaps for a 2 or 3 year project, do you need to provide annual updates on the size and composition of your research team? Or do you need to notify the data owner if the way that you're storing the data is going to change? For example, going from an on-premises server to a cloud service provider, do you need to notify them? Or as long as you're meeting the general security requirements, will that be okay? And then finally, what are you going to do at the end of your project? What are the terms for data disposition? Are you going to delete it? Are you going to archive it? Thinking about that when you're making the DUA is better than dealing with that at the end of the project. So as I pointed out with the Jenga-looking diagram, knowing what data are available is really important. But sometimes it isn't just knowing what data are available, it's understanding the quality of the data and whether they're going to be fit for use for the research project that is being proposed. It's important to look around to see if other researchers have used the same data. It's important to understand what data elements are captured. For instance, if you're looking at an administrative agency's application for services, there might be a lot of data, but their system might not be storing all of that with the same degree of quality. So understanding in advance of making a DUA what data are available is really important. How long will it take? It's going to take longer than you think it will. Just understand that. Negotiating the data takes a long time, and then getting the data can take a really long time, because even when there is buy-in from the decision makers, then actually getting an extract drawn and delivered can take a bit longer. It's important to know whether there is an established data request process, and if there is it possible then to modify that at all, or are you going to be able to get data just by filling out forms, for instance? Another aspect is the adherence to laws, regs, and policies that permit data sharing, especially if there's no established data request process. Asking an agency for data or an organization for data for the first time can be very alarming to them. They may not even have pointers already in hand to the laws that govern their data use or the policies at their organization that could permit or prevent data access. So it's important to see if they have templates or if they have an existing agreement with another organization, and to really learn what data sharing has been permitted before. If you are the first one that is requesting data, it's important to be patient and persistent, making sure that you are asking questions about what they are permitted to do, and making sure there's no legal barrier is going to be really important. It's important to think about this data use agreement as this balance between a data user and those data owners, the data providers. And the faces at the bottom reflect the perspective of that data provider or the data owner. They can look with fear at what they think of as a data requester that is just going to use or abuse their data. But if both parties are trying to balance the needs and the wants of the other, this process can go really well. And as I've already mentioned, all those steps in preparation are important. And then negotiating a sound agreement, being very clear on who has what responsibilities, and then being transparent about the results in the process. That's on the requester side. But then on the data provider side, making sure they understand their wants and needs, they understand the extent of or limitations of their documentation, and that they're very upfront about the amount of time it's going to take to extract and share the data, and then any conditions they might have for how it's being hosted. That's going to be really important as well. A piece that I think is often overlooked in data use agreements is consideration of the data subjects. So when a project is proposed and it's going to use administrative data, often linked administrative data, what are those potential benefits, costs, and risks to the data subjects themselves, and how will it be communicated to them? On the previous slide, I mentioned that transparency is really important, and thinking through an engagement matrix like the one on the right here that came from the report Nothing to Hide, which was done by Actionable Intelligence for Social Policy at Penn and the Future of Privacy Forum. An example of one of the tools that they have in this book is the engagement matrix. And so thinking through how the data are going to be, whether there's going to be engagement with the subjects or the communities represented is really going to be important. So in advance, read guides about data sharing, and chapter 3 for the handbook includes links to the text box that I have here on the right. These are some of the guides that I like to look at. Whenever you're wondering about certain aspects of a data sharing arrangement, call others, get help. You can call a privacy professional. You can consult a lawyer if you think that it's something that might be data sharing that might be pushing against a statute or a reg. And it's also great to connect the authorizers and the data people. So if this is the principal investigator and they get buy-in by folks at the agency that are going to approve the agreement, making sure that they have a conversation with the people that will actually know what's in the data and how the data would be extracted and delivered, that's really important to do in advance. So basically, to sum that up, do your homework so that the data use agreement process goes as smoothly as it can. And then develop the agreement. There is an appendix in the chapter, again, that's chapter 3 of the handbook, that has a lot of sample language. And this is sample language from various data sharing agreements. Many of them are sentences that are hybrids of lots of different agreements that I've worked on that have been at the federal level or the state level or the local level, some of which include language even with private sector contracts to get data. So look through the different headers in that appendix so that you can have a sense of how to start building out your own data sharing agreement if you don't already have a template. Even if you do have a template, I would encourage you to take a look through these, because sometimes you would see different phrasing or different elements to include. For instance, the lowest box there on the right, this can get into branding or how you're going to engage the community, and also whether there are going to be costs involved or a no cost agreement, how you just document that in a good DUA. So I'm hopeful that these example sections can really help speed up the process of at least getting the very first draft of a data use agreement together. So then some of the parts that should be called out in the agreement, especially when accessing data and doing data linkage projects, involve the personal identifiers, and these could be person or business identifiers. And if the user is going to get access to them, who can handle them? And are there any specific protocols for the handling of that personally identifiable information? Is there a separate monitoring or disposition approach for the identified data as opposed to the rest of the data? And would the data user, the researcher, need to certify that they've done certain de-identification before the rest of their team had access to the data? So just thinking all of that through, again, back to the 5 safes. This has to do with making sure that overall it's a safe project. If you're using the identifiers, it may need to be used in a safe setting or a specified setting, and making sure that it's clear on who the safe people on a project are that will have access to this most sensitive sort of information. And then just layering onto that, what sort of security requirements are there going to be? Does that have to do with the particular data set? Does it have to do with the laws that govern the collection and use of that data, or even specifics that are included in the regs? There may also be institutional requirements that if there's data sharing going on with a research team at a university, their university information services team may need to weigh in about what happens with high risk data or moderate risk data. And that's going to have to do with the sort of system and the sort of monitoring and control that's going to be needed. And as I mentioned early on, in many cases, an intermediary can help with this. So especially with these security and monitoring and control requirements, if there are data that you could access that are being managed by a good data intermediary, that's great. That might take a load off of your project team in order to really conduct the work with best practices. It would also be a way to control liability. But if you are getting data, especially identified data, making sure that you understand what would happen if there were a data spill in terms of liability is really critical, and making sure that you have your team informed for what to do if there are any data security issues. Output review. So this is assuming that you did the agreement and you're running your analysis and you're going to prepare your output. You are going to potentially have to review that with the data provider to make sure that you stayed within scope. They may want pre-publication review. It is critical when you are writing a data use agreement that you clear this up in advance, because there may be a lack of independence if they are going to require pre-publication review and edit. But sometimes data providers just want to review any outputs to ensure that they stayed within scope, and also to ensure that their data were used appropriately without challenging the findings of the studies. So that would be something more akin to the notification prior to release, that the project team has developed this report or these tables and they anticipate publishing them, and just giving the data provider that heads up that this is going to come out can often satisfy requirements in an agreement and build trust. So finally, the way that the output is going to be assessed in a data use agreement, make sure you note if there are going to be any requirements for capturing the code or the final analytic data set or any intellectual property issues. All of that should be in the DUA if it's going to be an issue. You don't want to find out after the project that you should have included these things in your DUA. And this is just following up on the publishing the results. I cannot stress enough the importance of making sure that the data owner is not surprised whenever your results come out. And it's also great to have them state in advance if they are going to want to be co-branded or cited in a specific way, that this project was made possible through data provided by whatever that organization or agency is. Some agencies have kind of the opposite stance, that they want to make sure that they are not mentioned by name. So making sure that that is clarified in advance, and if there is a specific stance, that it is articulated in the DUA is really important. So you do all of this, you write an agreement, you submit it, and the party you submit it to says no. What do you do then? Well, first, I think it's really useful if you think about why they might have said no. They might be afraid of you having a data breach. They might be afraid you're going to come out with results that don't match up with what their performance numbers show or what they've been telling their legislators or stakeholders. They could fear political backlash. They could fear just bad publicity. And they might just be fearing the burden of having their staff have to extract data. And all of that is being balanced against your project goals. So make sure that you can articulate what your project goals are going to be and why you need to use the data, that it's really essential for your study, and then think through all the various ways that you can try to reduce the risks that they're perceiving from using data in your project. Bear in mind that they might say no because they have a real or perceived legal barrier. So if they say, no, we can't, ask to see where in the statute it says that they can't share data. And if it's not illegal to share the data, they might say it's against our internal policies. Well, policies are easier to change than laws. So you might want to push on that or try to think of a way that they might revisit their policy or come up with an exception to the policy if they can be convinced that your project is really high value. The most difficult no is whenever it's based on the organization's culture. And so by that, I mean, they say, we never share our data. It's not illegal and it's not against any written policy. We just don't do it. That is difficult. And if you're trying to be the first data sharing with an organization, it might take a little while longer, but if you can convince them of the worth of your project, it can be really beneficial. It can also be incredibly beneficial if you can convince them that there's something in it for them, that they will gain insight that they don't have at the moment. And then finally, if they say no because of a financial issue, that this would cause undue burden on their existing staff, it may be worth looking into ways that you would be able to have cost recovery for the preparation and delivery of an extract. So more for this getting to yes beyond which I just said, it's important to see how others have succeeded, because sometimes showing an organization that there are existing data use agreements that others in their organization or in their field or in their jurisdiction have successfully shared data with researchers for research projects, that can often show them that the risks can be mitigated. And it's great to see these collections of data sharing agreements. And I'd encourage you to look through them to see if there's something that might help you along the way. Another great resource, it's the NNIP, the National Neighborhood Indicators Partnership at the Urban Institute. They actually have, this is a snippet from their website talking about why data owners say no and how to get them to yes. So this has examples and some embedded case studies there talking about how there have been transitions from no, you can't do it to yes, you can do it. So once you have an agreement, you get them to yes. It's important to get the agreement signed and to get it signed with someone with the authority to sign for your organization. And if you are a researcher situated at a university, this may require review and signature authority from your Office of Sponsored Research or Office of Research Services. It may require review through the Office of General Counsel, but getting it routed, approved, and signed by the appropriate party is going to be essential. In the past, I've seen instances where a researcher just thought that they could sign the agreement. Well, in many cases, they cannot if they are working within another institution. Once you have a signed agreement, making sure that you have good follow through is going to be critical to building trust. And by that, I mean making sure that you're staying compliant with the agreement. If they do require that you go and update them of any changes if you have to update the owner to changes in the composition of your research team, do it on time. If you find that you need to add additional data or extend the period of performance or any other modification, make sure that you allow time. That's part of agreement management, is making sure that the signed document reflects the work that is going on for the expected duration for you to get the project done. So it's really important that you do the work, and then also, to build the trust, explain your results to the stakeholders and the data provider. So that's just part of the life cycle of having a data use agreement, is negotiating it, getting it signed, getting the work done, and making sure that the entire project is tied off with the best possible outcomes for both the data provider and the researcher. So I'm glad to take any questions that anyone has. I hope that the chapter is useful to folks, and I am reachable at amy.o'hara@georgetown.edu. Thank you.